Good evening, Hearings Officer Frank. We are ready here in the room if you can hear me.
I can hear you. Can you hear me?
We can, thank you.
All right. I noticed on the participants' little button thing, is there anyone in the hearings room that I should be aware of at this point? I'm just trying to get a feel for who's here.
Yeah, so it doesn't look like we have anyone online, but in the room we do have the applicant and their attorney.
Okay, thank you. So you ready to go?
We are. I am.
All right. All right, thank you. Good evening. We'll go on the record at this point in time, and this point in time is 6 o'clock in the evening on May 21st, 2024. And this is a hearing for Deschutes County file numbers 247-24000-008-AD and 247-24-000-007-LL. I hope I got those numbers right. My name is Greg Frank, and I am the hearings officer in this matter, at least at this point. And before we turn to the particulars of the hearing, I would like to turn things over to Planner House to describe the electronic process and how it works. Ms. House?
Thank you. Give me just a second here to get this in full screen mode. All right. So for the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. And the item before the hearings officer tonight is a request for an approval for a farm dwelling and a property line adjustment in the EFU zone. So I'll start tonight's hearing by going over the hearing format and how to testify. I'll then present a brief staff report. Then we'll move on to the testimony portion of the hearing. The applicant will testify first. If any other persons attend tonight's hearing, those in support will go next and have 3 minutes. Then those in opposition would have 3 minutes. After the testimony portion, the applicant will be afforded 10 minutes for rebuttal. And lastly, staff may make closing comments at the end. And I'll note that the hearings officer can eliminate or modify the time limits. I didn't mention this, but the applicant will have 30 minutes unless specified by the hearings officer. So tonight's hearing allows for both in-person and remote participation. Regardless of how you're participating, if you provide testimony, please start by stating your first and last name and provide your mailing address. For those attending in the room tonight, hearings officer Frank or myself will call you up to the desk sitting to my right for you to provide your testimony. Please be sure to speak into the microphone so your audio is picked up, so that the hearings officer can hear you and so that your audio is recorded for future review of the hearing. Additionally, can you also write your name and contact information on the sign-in sheet, which is also sitting there on the desk. If anyone has joined us remotely since I've started, you must be attending using Zoom if you'd like to testify. Hearings officer Frank will ask you to use the raise hand feature to notify us that you want to testify. You can do that by pressing the raise hand button if you're on a computer or smartphone. If you've dialed in, you'll need to dial *9 on your keypad. So in addition to oral testimony tonight, you can also submit written testimony. If you're in person, please hand that to me before or after you provide your testimony. And if you're attending remotely, that will need to be emailed to me. And I recommend submitting any electronic submittals before the close of the hearing. And hearings officer Frank and staff are responsible for a orderly and respectful hearing tonight. If anyone's being disruptive, you may be asked to leave. So I will pause there and ask if there are any objections to the hearing format that I just described. All right, I'm not seeing any objections, so I'll turn it back to you, hearings officer Frank, for your hearing instructions.
Thank you, Ms. House. As Ms. House described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience as we make sure to get through each and every of the steps outlined. The application being considered is through the quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county comprehensive plan and land use regulations. regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and staff report are posted on the county's website, and they are also available directly this evening from staff upon request. It is important that you direct all your testimony to standards and applicable criteria. If you believe that a criterion applies that was not listed, you may address that unlisted criterion in your testimony or information to me. However, I urge you also to explain why this criterion must be applied and to do so with specificity so other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough specificity to allow other parties to respond adequately precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional issue or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as the county hearings officer in this matter. In that role, my job is to be neutral, a neutral decision maker, and thus, while I have had contact with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interest or the interests of any other participant in this case. To that end, I will state for the record that I do not have any relationship with the applicant, don't really know who they are other than by name on the documents, and I'm not aware of any connections I may have with other participants to this proceeding that would prevent me from remaining impartial. In this particular case, I do recognize and expect to hear this evening from applicant's attorney, Mr. Kobach. Mr. Kobach has been in numerous hearings, both at the City of Bend level and at the county, Deschutes County level. And I'm not sure if anyone's going to participate on behalf of Central Oregon Land Watch, but if so, I've had numerous contacts in prior hearings with attorneys on behalf of Central Oregon Land Watch. None of those contacts that I've had in prior hearings, I believe, impacts my ability to make an objective decision in this case. I have communicated with staff, but only to discuss the particulars of today's hearing, and that means logistical particulars and not the substance of any application. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient manner. And what I'd like to do before I turn it back over to the county is I want to make sure that you understand that if no one requests otherwise, at the end of the hearing tonight, the record will close. Okay, that means within about 21 days, I will issue a decision in this case. It is anyone who participates in the hearing, anyone's right to request the record to remain open. I want to make this perfectly clear because there was an issue in a prior hearing involving Central Oregon Land Watch, but I want to make it perfectly clear that if you wish the record to remain open, I would strongly suggest and really recommend that you do so during your testimony this evening. At this point in time, I'm not aware of anything in writing that would request the record to remain open. If the record does remain open, at the end of the hearing, we'll talk about logistics. That means how you get the information in the record and what timeframes that information may come in. So with that in mind, I would like to ask anyone who is participating or is in person or online, if someone has come online, if they wish to challenge my ability to hear this matter or to challenge the county's jurisdiction in this matter. So I'm going to turn it over to Ms. House. Anyone objecting to my ability to hear the case or the county's jurisdiction in this matter?
No, there's no one online and no one in the room has any objections.
All righty. With that, then I'm going to turn it over to Ms. House. It's your time and opportunity to give the staff presentation, and you may do so at this time. Thank you.
All right, so just kind of starting with an overview of the subject properties. Identified on the screen here in red as subject property 1. This property is identified on Assessor's map 14, 13, 17 as tax lot 900 and tax lot 101. This property is approximately 120 acres in size and is owned by Eric and Sue Haggerty. Subject property 2 is identified in blue on the screen. It's identified on the same Assessor's map, but as tax lot 400. Its current size is approximately 18 acres and it's owned by North End LLC. So the applicant's request has two key parts and then an update based on new information that was provided to the county on Monday. But the first request is a property line adjustment that will increase the size of, decrease the size of property 1, which is identified again as in red. That property after the adjustment would be approximately 82 acres. And then the property increasing in size is identified in blue, and that property will be approximately 56 acres in size. Additionally, the applicant has also requested as part of their initial application approval for a farm-related dwelling on the adjusted proposed parcel 1 or property 1. And as I mentioned before, the applicant recently submitted additional arguments on the dwelling approval requirements, and this was entered into the record on yesterday. So the staff report identified a few different potential issue areas for the hearing tonight. There's kind of 3 different areas that I'm going to identify for the hearings officer's consideration. The first kind of questions are all centered around what are the dwelling approval requirements for the applicant's proposal. So the first kind of key question is, how do the prior land use approvals impact their request? Is a modification of approval required? And lastly, if applicable, are the farm-related dwelling standards met, or has the applicant demonstrated compliance with the farm-related dwelling standards? The second key issue area is related to the lot of record verification requirements. The staff report identifies a question to the hearings officer of whether verification is required. And then if yes, are the subject properties legal lots of record? And lastly, staff is asking for the hearings officer to confirm that compliance with ORS 192, which are the statutory requirements for property line adjustments, whether compliance has been demonstrated as part of the applicant's submittals. And I think first key question that staff is asking for the hearings officer to focus on are the subject properties verified legal lots of record and or lawfully established units of land? And if applicable, does the proposal comply with the farm-related dwelling zoning standards? And I just wanted to go on the record tonight too, just to make sure it was clear to the hearings officer and other participants, the county's position on the EFU minimum lot size standards. This was briefly addressed in my staff report, but just to expand on that, the county is of the opinion that ORS 215-780 subsection 1A establishes an 80-acre minimum lot size unless a land division is proposed in the EFU zone. Then the Deschutes County Code section 1816-060 further establishes minimum lot sizes when a partition is proposed in the EFU zone. Additionally, LCDC, the Land Conservation Development Commission, verified compliance with ORS 215-280 subsection 2 and ORS 215-243 when the county adopted the lot size allowances that are called out in the 2 Deschutes County Code citations that are on my screen right now. And lastly, it's the county's position that lots or parcels that are smaller than the current standards are legal non-conforming, assuming they were lawfully created prior to the county's current land division rules. So moving back to kind of tonight's, I guess it touches on tonight's hearing, but just want to note that all record materials, including the recent submittal that I mentioned from the applicant yesterday, is published on the website on my screen. At the start of the hearing, I checked my inbox and my mailbox. I don't have any additional submittals sitting in there. So as far as I know, everything's published and available on the website to this current time. And that concludes everything I have in my PowerPoint presentation, but I am available for questions from the hearings officer.
Thank you, Ms. House. I'm going to hold my questions until at the end, which you'll have an opportunity to respond. This would be the time and the place then for the applicant or applicant's representative to come forward. First and last name, spell your last name, and give us a mailing address, please.
Pretty good, sensitive.
I guess so.
Okay. Wow. Good evening, Mr. Frank. Chris Kovac on behalf of the applicant.
Let's try switching your mic. Just a second. Sorry.
Yeah, that one's really.
That's gonna get better.
Oh, God.
Mr. Kobach, while you're signing in, I just want to make clear on the record that I've reviewed each and every document that has been placed into the record at this point in time. That includes your most recent submission that we received this week.
Sorry, hearings officer Frank. We heard all that in the room. I think we have the audio fixed, but I'm going to turn it back over to the Mr. Kovac and the applicant now.
Okay.
I'm going to start over again. Now we got the technology fixed. Good evening, Mr. Frank. Chris Kovac on behalf of the applicant, Sue and Eric Haggerty. With me is, my address is 937 Northwest Newport, Suite 220, band 97703. Mr. Haggerty is here and he'll give you his address because he's going to briefly comment on some evidentiary points that staff raised. Since you've read our material, I'll kind of just summarize, how we got here and what we think the issues are and how they should be decided. This started really from a simple lot line adjustment. Eric and Sue wanted to, for some state planning, move 40 acres tax lot 100 into tax lot 400 that is owned by an LLC in which Eric is a member. And he's been a member for years. And when Eric first met with the county without me, there were some complications. So I got involved. We met with the county and the county told us the only way to do the lot line adjustment was to requalify an existing dwelling that's on tax lot 900 as a dwelling using only the income from the lower properties, not tax lot 100. And it seemed like a logical explanation. So we did that. We filed Matt Blanton filed the lot line adjustment application. He's a surveyor and you have that in the record. And then I helped Mr. Haggerty put together this rather unique application from my experience is requalifying a farm dwelling. I've never seen that before. And so we did that. We got an incomplete notice from the county, which is fairly common. And we responded to that. They wanted to know a little bit more about the farming operation because what we did is to focus just on the income from tax lot 900 and 901 below, since everything was previously kind of accounted for as one farming operation. We had to figure out how to get the information that the county needed, which was the income isolated to just tax lot 900, the requalifying parcel. And so we broke it down to a per acre value and then did some math. And we got there because, Eric has farmed it since 2006 and has done everything the same way. All the acres are the same. It's irrigated, planted, fertilized, all the same. So that's what we did. Staff wanted a little bit more clarity on the operations and how we got to the per acre. We gave it to them. And then we got to the hearing. Well, staff recommended that we join the lot line adjustment with the AD application, administrative decision application, to requalify for some technical procedural reasons, and it made sense to us. So we did it. And then when the staff report came out, staff identified a question that we hadn't really thought about. And it is, does the lot line adjustment application really depend on any kind of farm income or any kind of requalification? And we dug into that. I dug into it since the staff report came out about a week ago. And my conclusion based on the prior decisions in the code is that farm income is irrelevant to the lot line adjustment. And there's absolutely no basis in the code to require any kind of quote requalification of the existing dwelling. And I get there this way. When you read the permitted uses, there's two sections. One is the section that applied back in 2004, and that's 1816 25 or 20 25 025 025. And that says you can do a farm-related dwelling, but you got to meet certain income tests in 1816.050. And that's what happened in 2004 when the prior owner had it and they got qualified, is they had to go back and justify this farm-related dwelling. But when you look at that criteria, the only look it requires is a historic look. You have to show that for the last 2 years or 3 of the last 5, that was the code at the time, that you had $80,000 of farm-related income. And then there's some other tests that has to come from property you own, obviously, and there's some other standards, but that's the test that applies. You have to look backward. There's nothing in 18.16.050 that allows the county to require you to justify income in the future. So in other words, based on the plain text of the code, once you qualify as a farm dwelling, income's irrelevant. If the year after you are qualified, you produce no income, you're still a lawfully established dwelling on that property. And so then you go to the next section that's important, which is the replacement dwelling in 18.16023. And that, or I guess that's, no, 16.020. That's what uses are permitted outright in this zone. And subsection J states that a replacement of a lawfully established dwelling is allowed outright. And again, when you read all of the criteria, it is subject to the provision I just mentioned, 18.16.023. And you apply that criteria, and again, there's nothing in that criteria. When you go in to replace your dwelling, nothing requires you to look at any kind of income, past, present, or future. So the test is very simple for a replacement dwelling. All you have to establish is it lawfully created? You check that box. Did it have all the elements, the roof, the plumbing, the heat source, etc., to qualify? Check that box. Every requirement you have to look at whether it was demolished or destroyed by fire. Those didn't apply. So all of the criteria that apply were met for a replacement dwelling. There's no requirement that you have to look at income or you have to go back to the prior approval of a farm-related dwelling and further justify any kind of income test. You have the right to replace it. So that replacement dwelling under the code is its own use. It's unrelated to any farm income tests or anything under any of the other provisions. And then you go look at the decisions in these cases, and they're in the record. That staff did a great job of going back and putting them together. In the 04-13 decision was the one that approved the original farm-related dwelling from the prior owner. Again, there's 0 conditions. I have it here. 0 conditions of approval that required any future demonstration of any kind. There were 3 conditions of approval. None of them relate to farm income. And then you go to AD 12.7, which is the replacement dwelling, the same thing. There was no requirement to look back at the prior income test, and there was absolutely no condition that farm income in the future be justified for the replacement dwelling. So our position, and I think, staff may share this position a little bit, at least I don't think they're opposing it, is based on the text and context of the provisions in the code. The only thing you look at now for the lot line adjustment is the lot line adjustment criteria. There's nothing in the code that allows the county or the hearings officer to go back and say, I'm going to require that you requalify the existing dwelling, because it's not a farm dwelling anymore. It is its own approved use. It is a lawfully established replacement dwelling. And as I said, that's treated very, very differently under the code. And so if you accept that analysis, then a lot of these issues go away. We don't have to talk about whether or not the acreage we used is correct. We don't have to talk about any of the farm income standards in 050. We don't have to talk about whether we have to use contiguous property. We don't, but none of that comes into play. And we also don't have to get into this modification requirement, because the modification issue came up based on whether or not our request to requalify was really a request to modify the prior farm-related dwelling application approval. So we would avoid that, and we would go right to, do we meet the standards for a lot line adjustment? And that's pretty straightforward, we think. We've got a couple of issues. I've addressed them in my letter. The first one is the lot line, or the legal lot of record. And from what I read in the staff report, I think we pretty much track, which is, we're not required to verify either tax lot 900 or property 1, which is tax lot 100, 900, or tax lot 400, because the exception in 822.440 something, I forget exactly what it is, states that if the property has been determined to be a lot of record in a prior land use decision, it's exempt from going through that verification process. And you might remember this from a couple of hearings I've done with you, is that I think the reason that exception is in there, and I think it's so important, is that's the law. We had the case, the Ganson case, Michael Ganson versus Lane County. It's LUBA number 2020-074, where we had a very similar situation where there was a prior land use decision that declared a legal lot of record. And years later, the owner applied for an application for a different use on that property, and a hearings officer made a decision that it was not a lot of record. And LUBA reversed that, finding that that type of analysis was a collateral attack on the prior decision declaring it a lot of record, and the county could not do that. So we believe that that exception that we're relying on for not needing verification is the only, it has to be applied here, because that's the law. You cannot go back in another decision and say, those decisions are wrong, it's not a lot of record. But I would also say that I think they've both been verified as lots of record, or determined lots of record, because in the staff report, we know from the lot line adjustment in 98, tax lot 100 and 900 were consolidated as a single lot of record. And then in 1974, there was the minor partition that created tax lot 400, and that was approved by the county. And in 1974, there was no ordinance requiring anything more. The first partition ordinance, I think, in Deschutes County, and Ms. House can correct me if I'm wrong, but from past cases, I believe the first partition ordinance was in about 1977 or 1978. So at the time that lot was created, I think everything was done legally necessary to create it as a lot of record. So that issue should be, we think, is pretty easily resolved. Now, on the lot line adjustment, you know, when the surveyor did it, I gotta support him a little bit. He prepared the application consistent with the application form in Deschutes County, and it just doesn't mention ORS 192 or 92.192. So he didn't address all of that criteria in his application, and I couldn't find anything in the code today that really directs you to that statute when you're filing for a property line adjustment in Deschutes County. But nonetheless, you know, staff has raised some questions under 92.192, and I think we can quickly knock those out. On subparagraph 3, it says that the county can approve a lot line adjustment if one or both of the abutting units of land are smaller than the minimum parcel size before the adjustment, and after the adjustment, one of them is large or larger than the minimum. And that gets back to the discussion Ms. House just had about what is the minimum size. I personally think under the code, the minimum size in this area is 35 acres. And I get there with this analysis. If the code expressly allows you as an owner to create an irrigated farm parcel through a partition process that is 35 acres, and in this sub-district that is allowed, it's 18.16.060 or 065, allows you to create these irrigated parcels in this district. And both of these are irrigated parcels. So I would say that 35 acres is the minimum, but worst case, under state law, 80 acres would be the minimum for high value. And I think that clearly under either of those, we are starting with one of the parcels being smaller, tax lot 400 is smaller than the minimum. And after, we're gonna have one parcel, tax lot 900, that is larger than the minimum. It's gonna be larger than 80, it's gonna be larger than 35. So I think we check that box. And then on 4, there's the prohibition. It says you cannot use a lot line adjustment to decrease the size of a lawfully established unit before the adjustment of the line that is smaller than the minimum. If you're creating a parcel, another lawfully established parcel, if you're increasing it to a size that may make it qualify for a lawfully established unit of land for a dwelling. And so I think you have to, the prohibition only applies if 2 things are occurring. One is you're decreasing a parcel below the minimum, and we're not doing that. We're decreasing tax lot 900 in 101, property 1 to above the minimum. And so the rest of it's kind of irrelevant, even if we're creating another parcel that is large enough. And I know staff didn't say it is large enough, and we're not saying it's large enough. I think that's premature, but even if you were to assume that tax lot 400 adjusted would be larger than the minimum, it doesn't matter because both of them have to apply before this prohibition kicks in. That's sub A. If you go to sub B, it's the same thing. You have to, the first part of the test is the prohibition only applies if you're decreasing a lawfully established unit of land to a size smaller than the minimum. So whatever you use, 35 or 80, we're not decreasing either of these below the minimum. We're only decreasing one, which is tax lot 900/100, parcel 1, and we're decreasing it to a size that is still larger than the minimum. So we don't think that prohibition applies at all. And so I think if you agree with us that, you know, the income tests and the requalification is not part of this, it's not required. It was just an erroneous statement at the pre-app. And then we go down to just the lot line adjustment criteria. I think we checked all the boxes. We agree that you can't use a lot line adjustment to qualify for an acreage test, but we're not doing that. The acreage test is different. The acreage test only applies in non-high value areas. So if you don't even have to do the income test, as I understand it, under 1816.050A, if you have a big chunk of low value farmland, but it's got to be like either 160 or 320 acres, but that doesn't even apply. And so we don't have to deal with that. So I think that we've hit all of staff's concerns. I would say this though, if for some reason, and you may disagree with me on whether the farm income standards even apply. And if you do, then you got to go to, can we requalify this? And I think the only issue there is, do we meet the farm income test for the last 2 years? And we gave, for 2022, we qualified even using staff's numbers. There was a little difference on, there's 153 acres that are technically have water rights. But as I explained in my letter through Mr. Haggerty, from year to year, the total acreage used can vary based on whether you're fixing some irrigation equipment here or here. And so we used a slightly lower number for the acres for our formula, but then we redid it in my letter using the 153 acres. And for 2022, we're still way above the threshold. And then we did get our tax returns, Mr. Haggerty's tax schedules. And so the per acre for 2023 was way above the required minimum. And so we would meet the test, we think, to requalify for the last 2 years for just tax lot 900 if you apply our formula. And again, I explained that the formula is really this, is Eric and his wife have farmed the exact same property, the exact same way. No acre is different than the other acre. None of the crops are different. None of the farming operations are different. None of the fertilizer is different. There was a question about cattle. I started it. It was my mistake. I referenced, because it's Haggerty land and cattle, that there may be cattle on the property. Mr. Haggerty's here to tell you that since 2009, there hasn't been a cow on the property. And other than rodents, there are no animals on the property. So Mr. Haggerty, I'd have you just confirm that.
Yes, sir.
Give me your address too.
Eric Haggerty, 8800 Northwest 31st Street, Terrebonne, Oregon, 97760. That's correct. When we first bought the farm in 2005, and moved onto the property in 2006, I had cattle at that time. And by 2009, I got rid of all the cattle and went back in the construction business because it's much more profitable. So we have not had any cattle since then. We're strictly growing orchard grass hay since that period of time.
And can you expand on what I said about how the operations are consistent through acre by acre?
Sure. Yeah. Over the years, I've expanded our irrigation with different methods of pivots and pumps. And I won't bore you with all the details, but the way I irrigate's it's the highest standards with all the different turbine pumps and stuff I've improved over time. So the income test we done that we referenced was based off the total amount of income that the tax records show every year. And that's, I farm the property the same every year. I'm not a full-time farmer. I have other businesses, but the way we irrigate, the way we hay, the way we fertilize, typically 3 cuttings every year. It's almost a mirror image from year to year to year since 2006. Very close, other than I believe 2 years we've had some cover crop rotation to where that orchard grass was out of rotation, and that just changes things by roughly 16 months. But overall, it's been very much identical in
Can you
production.
comment on how per acre you can conclude that each acre is the same from an income standpoint?
Yes, sir. So my gross tax records show income strictly from hay, and the only way I can feasibly come to that conclusion is we have, we're farming so many acres, and I sell that much hay every year, and that's our gross income. There's really no other way to do it but take the total amount of acreage, divide that by a gross income. I don't see any other way to
But how
break
do you
that
get
down.
to each acre being the same?
Well, it's all irrigated the same. We do have, some areas, some rocky areas, different soils in a few spots, our edges, ATV paths for ingress, egress, irrigation ponds, so on and so forth, that don't quite produce like, the rest of the place. But overall, it's the same amount of ground every year. It's the same fertilizer. So it's just a repetition every year for meeting that same income. Obviously, the price of hay fluctuates year to year, and the price of inputs fluctuates. So that changes. But farming practices certainly, for me, haven't changed. And I farm my property and then another quite larger piece of property down the highway, and I operate that the exact same way as I do my place.
Thank you. Unless you have any questions, Hearings Officer Frank, that's the applicant's presentation.
Sure. You may be asked questions shortly, but let me just see what else is in store here. So is there anyone else here to testify, Ms. House?
No, so staff, Will Gross, the Deschutes County Planning Manager, wanted to add just a few comments, I believe, for your consideration, but it's not, it's more just kind of closing comments. So I don't know if you.
That's fine. Yes, if Mr. Groves wants to identify himself, just as an alert, I will, following Mr. Groves' testimony, allow Mr. Kobach a response. But this is one of those issues, quite candidly, that more information is better than less information. And more input both by staff and any of the participants in this hearing will be greatly appreciated. Go ahead, Mr. Groves.
Thank you, Hearings Officer. Will Groves, Planning Manager for the record. I don't know that this affects the case materially, but I wanted to point to the issue that the minimum lot size in this case isn't a simple matter. And it's something that, reasonable and very bright attorneys have struggled with over the years with our EFU code and how to read the statute and the code together. I like that the applicant's proposal works if the minimum lot size is either 80 acres or some other size acreage. the extent you were looking to make a determination about what the minimum lot size in the zone is, I want to advocate for a particular position associated with that, and I'm going to describe that now. The way that we understand, in the face of tremendous ambiguity, the cumulative effect of the statute and our local provisions is that we do not specify a minimum lot size in our local code and revert to statute and the 80 acres associated with that. Statute also then provides what are colloquially called go-belows. So counties could go through a process with LCDC to have, what was our farm study and our subzones created. And as a result of that, we've received a statutory allowance to have smaller land divisions for certain irrigated and non-irrigated land divisions. And there's a question if those are then effectively minimum lot sizes. And consistent with prior hearings officers, and I think you might have been participating in one of these, that we have other zones that specify sizes for land divisions, but do not specify sizes for minimum lot sizes. And prior hearings officers in those cases have determined that those zones have no minimum lot size consequently. And for that reason, for some period of time, our hearings officers concluded likewise that the EFU zone had no minimum standard for lot size. And then in consultation with Deschutes County Legal Counsel, it occurred to us that in fact that the statutory backing, in the absence of us having a local minimum lot size stated, that the statutory backing of 80 acres is likely the minimum lot size that would be received. So in sum, our position is that the minimum lot size comes from statute. It's 80 acres. We've received go-belows that allow certain types of land divisions in certain circumstances to be smaller, but that those don't affect new minimum lot sizes. So for example, if I had, 35 irrigated acres in a zone and I had an 80 acre parcel and I wanted to reduce my parcel from 80 acres to that 35 minimum irrigated acres that could be afforded for a land division, we believe that that 35 irrigated acres is not a minimum lot size in that case. It makes you eligible for certain types of land division, but not a minimum lot size. I just want to note that, again, that attorneys who I respect tremendously over the years have strong and very differing feelings about how this works. And to the extent that we could dodge this question, this matter, it would make the record significantly simpler.
Understand, sir. Thank you. Anything else?
No,
Mr.
that's
Grove?
all. Thank you.
Thank you. Anything, Ms. House? At this
I don't have
time?
anything to add, but I just wanted to confirm if you had any questions. I didn't know if you wanted to ask them now or if your questions have been answered either by the applicant or by Mr. Groves.
I'm going to ask you, and then I'm going to ask Mr. Kobach the very same question. And it's more of a procedural process question. And that is, having heard the other side, in your case, having heard Mr. Kobach speak this evening, is there anything that you wish additional time to clarify by keeping the record open and submitting additional information into the record? That's a simple question. No pressure, just a simple question.
I think the county doesn't have anything else to add with Mr. Groves' testimony. I think that really clarifies again the position on the minimum lot size issue. But I would be interested to see what the applicant's team, if they have an interest in an open record period.
Thank you. Mr. Kobach, same question to you.
Thank you, Mr. Frank. Well, first, I appreciate Mr. Groves' comments. I agree. There's some ambiguity. I look at it more intuitively, which is if you can create a parcel of a certain size, that's the minimum size. Because if you couldn't, then if that wasn't the minimum size, you wouldn't be allowed to create a lot that size. So, but I can see there's different perspectives and I appreciate the county's position on it. And I do think we've dodged it because, as I said, when you apply 92.192 and those, really there's just two provisions. One that's real critical, subparagraph 4, it's the prohibition. It only applies if you're decreasing one of the parcels below the minimum, and whether you use 35, my number, or 80, the county's number, we meet it. So that's what we have to say on that. I don't really think I just want to clarify that I want to make sure that the new tax schedule that I attached to my letter got in the record.
Yeah, I can confirm it's in the supplemental application materials that were uploaded on Monday.
So that was the only thing I wanted to make sure we have in the record. We really don't have any anything more that we can add. I think my letter is the best analysis that I can give you on why we don't have to requalify the existing replacement dwelling, because it is a replacement dwelling. It's not a farm dwelling anymore. And I think that's the only fair reading of the code when you apply State versus Gaines, PG versus Boley, and any of the cases that follow it. When you read the plain language of the text, that's the conclusion I think you have to reach. And I think it's supplemented by, if you do go outside of the language of the code and you read the prior decisions, there are no conditions that would lead you to a different result. So we're pretty comfortable with the record, and we don't need it kept open.
Thank you. Just to confirm, I'm looking at a May 20th, 2024 letter from Mr. Kovac. On the very last page, there is a Schedule F 2023 for Haggerty Land and Cattle LLC. Is that what you're referring to, Mr. Kovac?
Correct. That would be relevant if you got to the requalification. If you determined that I was not correct on my analysis, yes, that would be
Okay.
important.
My question relates to, you wanted to make sure it was in the record. Is that the
Yes,
document
yes,
that you were talking about?
Yes. Yeah, exactly.
Okay. All righty. Thank you. Ms. House, anything further?
No, nothing else to add.
Okay, thank you. Mr. Kovac, last call.
I have nothing else I can add. Thank you very much for your time this
All right.
evening.
Appreciate it. Since no one has requested the record remain open, we'll close the record at this time. My decision will be due within 21 days of the hearing date today. So I appreciate everyone's participation. I appreciate the information you provided into the record, and it sounds like it's going to be an interesting analysis, and I look forward to making the decision. And so I appreciate that. With that, I'm going to close the public portion of the hearing and wish you all a good evening. Thank you. We'll close the hearing.
Thank you.